Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing recent decision by the United States Supreme Court. So SCOTUS, we're dealing with a recent decision involving immigration. And when these cases pop up, it's wise to take heed of them when you're dealing with immigration on a regular basis, as we do here, specifically me. I've been doing this for almost 17 years now. That said, I thought of making this video after reading a recent article from the AP, that's apnews.com. Article is titled, "The Supreme Court Rules Against California Woman Whose Husband Was Denied Entry to U.S." So, quoting directly, the Supreme Court on Friday ruled against a California woman who said her rights were violated after federal officials refused to allow her husband into the country, in part because of the way his tattoos were interpreted. The 6-3 decision along ideological lines, I think that's interesting that they made that as an aside. I don't view this as ideological lines. This is jurisprudence. This is folks making decisions. These are the Supremes making decisions. They're making findings of fact and conclusions of law, primarily. They're making conclusions of law even, not even findings of fact, primarily. Again, how is that ideological? I'm really getting sort of tired of, especially the media and the media in the United States, constantly trying to politicize our legal process and then just takes no heed of when our criminal process gets massively criminalized. That's getting pretty old to watch that, even from abroad. Quoting further, the 6-3 decision along ideological lines found that citizens don't necessarily have the right to participate in federal government decisions about whether immigrant spouses can legally live in the U.S. Well, first of all, yeah, I've done videos on this, including one made contemporaneously with this one regarding this article specifically, where we discuss, yeah, you don't have an unfettered right as an American if you marry a foreign national to bring your foreign national spouse to the United States. You have a right to marry them. You can't be precluded from doing that under our Constitution and our laws. But yeah, if a foreign national does not have an unfettered right to enter the United States, whether they're married to an American or not. Now that said, what we're talking about in this video is consular processing and the notion of reviewability. What are we talking about with regard to reviewability? Well, there's an old case regarding what's called the the notion of the doctrine of consular absolutism or consular non-reviewability. Basically, way back in the early 1800s, I think the case is from 1803, there was a case where somebody got denied a visa, I think it was in Canada. They took the case up through the federal courts and said, we want this reviewed and appealed. And the court said, hey, we're not getting in the business of looking over the shoulder of fact finders in our State Department apparatus. What are we talking about here? Consular officers who are mandated with the task of ascertaining and adjudicating whether or not someone should be granted a visa to the United States. Basically, the Supreme Court at the time said, we're not going to get in the business of second guessing them because we're not the boots on the ground. So they basically are given a great deal of latitude. Again, it's called the doctrine of consular absolutism or consular non-reviewability. And they're just granted a great deal of latitude with regard to their fact finding. Now, in the context of this case, we're talking about a different section of the INA, the Immigration Nationality Act. Consular non-reviewability issues come up a lot when I talk to people, especially out here who are applying for tourist visas, primarily for spouses, Thai spouses, and significant others to go to the United States. Under that analysis, oftentimes the consular officer will cite Section 214B of the Immigration Nationality Act. They'll basically say you haven't demonstrated strong enough ties to your home country and weak enough ties to the United States. But people will say to me, but they didn't back it up. They didn't cite any reasons or anything. At the end of the day, they don't have to. They make they're the primary fact finder, and their fact finding conclusions are really not subject to review. That said, and I'll get into this further, there's consular absolutism, and then there's arbitrariness and capriciousness in the actual processing of cases. Let me explain what I'm talking about here. Quoting further, the majority ruled against Los Angeles civil rights attorney Sandra Munoz, who was last able to live with her Salvadoran husband nearly 10 years ago. The couple started the process of getting an immigrant visa after they married in 2010. Luis Asensio Cordero, who had been living in the U.S. without legal status. I love the terminology here. Living in the U.S. without legal status. No, that's not correct. This person was an illegal alien. They were unlawfully present in the United States, which I'm sure that factored in mightily in the analysis by consular officers throughout this case. Meanwhile, not even getting to the issue, and we'll get to the procedural stuff here in a moment, if this person was unlawfully present in the United States for a prolonged period of time, that in and of itself, entering illegally, in and of itself could be deemed a ground of inadmissibility. Again, it would depend on the facts in the underlying case. I don't want to get into that directly, but understand, yeah, there are legal grounds of inadmissibility, and oftentimes those who are barred or deported or subjected to what's called expedited deportation under IRA, an act in the late 90s, those folks are banned for a certain period of time, overstayers as well, banned from returning to the United States, and under those circumstances, they have to seek a waiver. So, even, and again, I have some issues with the way that the consulate processed this, which I'll get into in a moment, but it shouldn't lead people to be distracted from the fact that this was not exactly a clean hands immigrant, if you will. This was somebody who was previously illegally present in the United States. That's worth noting. Quoting further, had to travel to the consulate in San Salvador to complete the process. But once there, the consular officer denied his application and cited a law denying entry to people who could participate in unlawful activity. Well, interesting that that's brought up, because the mere fact that this person was illegally present in the country previously would lend itself to that inference. I mean, again, I'm not trying to argue against the people who lost this case. It's sad, and I do sympathize with somebody who has to be separated from their spouse. But that said, at the end of the day, a lot of the problems we're seeing, especially along the southern border in the United States, primarily, the primary source of all of this is the fact that U.S. immigration law has been largely disregarded, especially here recently. I mean, acutely here recently. That said, quoting further, the consular officer denied his application and cited a law denying entry to people who could participate in unlawful activity. Now, here's where I get a little bit peeved, and I think that Department of State could do better about this stuff. Quoting further, the State Department would not give a more specific reason, but after filing a lawsuit, they learned the refusal was based in part. Again, the way that this is framed is interesting to me, because it seems to be trying to sort of gloss over the fact that this person was physically present in the United States for a prolonged period of time illegally. They're focusing on other things, which are worth noting, and I'll go into for the consular processing part of this analysis. But again, don't take your eye off that ball when you're reading these kind of reports. On a consular officer's determination that his tattoos likely meant he was associated with the gang MS-13. Okay, now there's a couple of things here. I don't know. And maybe consular officers that are stationed in South America are given some sort of training course on identification of tattoos associated with various underground groups throughout South America. I kind of doubt it, but I don't know. They could be. That said, again, I've seen this a lot in practice over the years. Consular officers are very cagey, and sometimes they're very, quite honestly, and this is kind of a nice way to put it, non-confrontational, and don't want to explain themselves when they make these determinations. I would say it would be very nice in the future if Department of State would stop falling back on opacity. You have the legal foundation to make the decisions you make. Make them and be clear about why you are making them. Stop all of this kind of, we want to keep it nebulous. And, I get it. I have to push cases through the logjam that is administrative processing and all this kind of thing quite frequently. Again, I don't have any problem per se with the doctrine of consular absolutism. I actually kind of agree with it. I think that, and this was an early Supreme Court decision. We're talking founding father type people were on that court that made that determination. And I think the principle is a good one. Our courts should not be clogged up with trying to second guess what folks stationed at embassies and consulates abroad, what decisions they made with regard to applications for visas. Don't get me wrong, I agree with that. But one thing I would criticize here, because I've seen this in practice myself, is when officers make a decision, they don't just come out with it and they don't just say, this is the decision, it is what it is, deal with it. They sort of want to kind of obfuscate sometimes, or obfuscate might not be the right word, but they just don't want to have a confrontation. Well, guess what? You're the adjudicator. Adjudicate. You know, I remember at one point they transferred in here a young lady who was a consular officer for some years. She was quite nice, very professional. After she left, if I recall, back when I was on Facebook, I think she friended me on Facebook. We exchanged some messages after she was out of here. But you know, one thing I told her at the time, and something I've said ever after, is one thing I really appreciated about her is she would just come right out to the window and say, nope, denied on this. Well, you know, as an attorney, I need a final decision in order to go back to the client and then make further decisions and strategize further about how to gain a remedy. And up to that point, the issue we were having was oftentimes here at the consulate, now bear in mind, this is like 15 years ago, but a lot of the consular officers, they didn't want to go out on a limb and make a decision, an overt decision. This person happened to be legally trained. In fact, I think, if I recall correctly, she went to an Ivy League law school, if I recall right. Again, very good consular officer. And frankly, we had a lot of talks about immigration law over time, and it was interesting to operate up against, not up against, but to be adjudicated and deal with adjudications by somebody who was very confident and knew what they were doing. Again, we don't all have to, you know, consular officers oftentimes will do maybe a year sometimes of their whole career in the visa section. It's part of that well-rounded experience all those officers have to sort of undertake, if you will. Make a decision. It's okay. You're protected by the law, as the Supreme Court has noted. My big problem is when a decision is either not made or it's sort of made and then it's just like, well, but we're not going to give you the underlying reasoning. That I have a problem with. And I think the Supreme Court has effectively said in this case, well, there's not really much you can do about it. Well, fine, but maybe not legally. Is this something that you can find a remedy to? But one would think in terms of a public policy position, it would be a good idea if Department of State was transparent as to the reasoning behind why they deny applications for visas. What's wrong with that? That's good public policy. That's a good idea. In any event, quoting further, Ascencio Cordero has denied any association with any gang and has no criminal history. The tattoos, including Our Lady of Guadalupe, theatrical mass, and a profile of psychologist Sigmund Freud. Wonder what Freud has to do with Latin gangs, but okay. Quoting further, instead expressed his intellectual interest in Catholic faith, his lawyer said in court papers. Now, it's interesting here because the, quote, the U.S. Ninth Circuit Court of Appeals sided with Munoz and ordered the State Department to share the reason and reconsider the visa application. That ruling was tossed out by the Supreme Court after the State Department appealed. Let me just say, I actually agree with the Supremes on the underlying holding, which is, yeah, sorry, the consular officers get to make these determinations and the courts will tend to defer to them. That said, I think it's worth noting, I think that the State Department should have to share and show full transparency with regard to the why of the denial. Now, I get that they can deny without, you know, and not be reviewed. But again, you know, my answer in this would have been, yeah, I'm not letting that person back in. They already were in the country illegally. I wouldn't even get into this analysis of tattoos and things of this nature. Now, again, I don't know the facts in the underlying case, and maybe that alone was, maybe this person was in, for example, duration of status the entire time they were in the United States, and then maybe you don't have necessarily a legal reason to find them inadmissible because they might not have technically been in violation with the law. But that said, you know, again, my bigger issue here is not that consular officers can deny visa applications. My issue with all of this is, and has been for some years, that oftentimes Department of State personnel, for whatever reason, I don't know if, again, they are afraid of some sort of confrontation, there's some sort of hubris involved where they just, I don't care, I don't want to share, you know, my reasons are my own or something of this nature. If it's arbitrary and capriciousness, I don't know. But again, I don't have any problem with the notion and the doctrine of consular non-reviewability, but failure to give a reason, failure to cite the reasoning for a denial, I don't think that's acceptable.